I consider it my proud privilege to introduce to you our distinguished dignitary for today, Sri Mohan Katarki. Mr. Mohan V. Katarki is a senior advocate in the Supreme Court of India. He has represented states of Karnataka, Punjab, Kerala, and Odisha in various high-profile interstate water disputes before the interstate tribunals and the Supreme Court. He is a member of Editorial Advisory Board of Bangalore University Law Journal, member of Karnataka State Law University Students Law Review, and member of the Board of Management and Planning, Karnataka State Law University. Mr. Katarki developed a specialized practice in interstate water law concerning sharing or allocation of waters between the states in the interstate river and river valley. He has represented Karnataka state in Krishna, Kaveri, and Mahadai river interstate water disputes before the Honorable Supreme Court and tribunals for resolution of interstate water disputes and rendered valuable contribution to our state. He has also presented papers at various national and international conferences and seminars, including the Regional Conference on Water Resources at Teslik, Bosnia in 2001, International Water Law Conference at Colorado Law School, USA in 2002, Interstate and International Water Dispute Seminar conducted by the WB National University of Juridical Sciences, Kolkata in 2013, and Law Asia Biennial Conference at Sydney in 2015. It's indeed an esteem to have you here, sir. Over to you, sir.
Thank you, Pooja, for your nice introduction. May I first thank the faculty of University Law College, Bangalore for arranging this special lecture. It's my privilege to be the second speaker of this prestigious lecture. Today we have chosen a topic which addresses on the international law. During the lockdown, we all function from home. So as I, with some makeshift arrangements, I've been speaking from the home. I'm sure you'll all bear with me. The topic for the day, the Great Ethiopian Renaissance Dam, Nile basin split wide open. We are not going to speak on this topic from the standpoint of either downstream state of Ethiopia, midstream state of Sudan, or upstream state of Ethiopia. Sorry, I said downstream state of Egypt. The concern of ours should be to speak from the concern of the international community, what obligation the international community owes in securing peaceful solution to this problem. The dam proposed by Ethiopia on river Blue Nile is a massive dam. $4.8 billion have been spent in the construction of this dam. It's almost 7% of the annual GDP of Ethiopia. If this dam is constructed, the downstream state of Egypt cries foul. According to Egypt, this will have an impact or almost ruin its farm economy, which is about $1.8 billion annually. Besides, it will have cascading effect on the economy of Egypt. Similarly, the midstream state of Sudan too has serious grievances to complain. On the other hand, the upstream state of Ethiopia, which has constructed this dam, in a record time of 7 years, feels very strongly about the importance of the dam. The dam will have a capacity to produce power of 6,000 megawatt. It is in fact stated by the experts that once the dam is complete, in fact, it is almost complete, and it starts generating electricity, Ethiopia, a poor nation, will emerge industrially, and it will be the largest exporter of power in Africa. Therefore, this dispute has assumed huge importance, and the importance lies in the international community from other angle also. Because these three states, Egypt, downstream, midstream Sudan, and upstream Ethiopia, are at the Suez Canal. The Suez Canal is the most important canal, started in 1869. It carries today about 13% of the world trade. Therefore, if the conflict between the three states remains unresolved, and if it were to flare up into an armed conflict, or what you call water war these days, this will not only bring the economies of the three countries into trouble, this will severely affect the Asians because, as I said, 13% of the world trade passes through the Suez Canal. Therefore, it is all our concern to discuss, deliberate, and suggest a solution, if possible, to the three states so that all of them can live peacefully and enjoy the benefits of the nature. To begin with, we all know that water belongs to us all. Nature did not make the sun one person's property, nor air, nor water, cool and clear. This is what Michael Simpson said. The water in the river is around 3% in the world. 97% of the water in the sea. And out of this 3% of the world water, 1% is in the underground, 1% is frozen in the ice, and remaining 1/3, that is 1%, is available as a fresh water for all of us to use it for various purposes, including the drinking water purpose. The solution, to start with, for this great dam is not easy. The crux of the dispute is, as you all know, the large part of the water of Nile, about 80% of the water, is being consumed by the downstream state of Egypt and Sudan. This happens with any other basin also. The downstream states, usually the deltaic states, have lived with the water for centuries, and they have utilized the water because of the natural topography of drainage basin. Egypt, so as Mesopotamia, so as Mississippi or Indus, or back home Kaveri, Krishna, Mahanadi, the deltas have utilized the water, no doubt about it. The Nile was largely utilized by delta in Egypt. The disputes arose in the early part of the 20th century At that time, the real disputing state was Sudan. Sudan claimed its right to construct a couple of dams on the main river Nile. Egypt objected. The Britain was the power at that time which had a hand on both Sudan as well as Egypt. So they were able to broker some kind of an agreement between the two nations in 1929. Later, in 1959, Egypt and Sudan entered into a comprehensive agreement to share the water. But unfortunately, both these nations forgot that Nile does not belong to only Egypt or Sudan. There are 11 basin states, and immediately above Sudan, there is Ethiopia, which contributes about 85% of the water. No provision was made with regard to the utilization of water in Ethiopia. The agreement was between the two nations. Therefore, it has no binding effect on the Ethiopia. But there was one old agreement, colonial agreement of 1906, if I am right, 1902, between the Great Britain, which was speaking on behalf of Egypt, and King of Ethiopia. This agreement, similar to the agreement we saw at various places imposed by the British, including the Kaveri River in India, dictated that the lower riparian state, that is Egypt, will have a veto power. If you can just read the agreement, very interesting it is. Clause 3 of the, or Article 3 of the agreement states, His Majesty Emperor, King of Ethiopia, engages himself towards the government of His Britannic Majesty not to construct or allow to be constructed any work across Blue Nile, Lake Tana, or Sobat, which would arrest the flow of their waters, except in agreement with His Britannic Majesty's government and the government of Sudan. This means Ethiopia cannot construct any work across Blue Nile or Lake Tana or Sobat without entering into an agreement with Egypt, that was represented by Britain, and Sudan. Therefore, under this agreement, the downstream states almost got a veto power over the Ethiopia. In these circumstances, the overall water dispute has to be understood. Subsequently, in 1959, as I referred to already, both Sudan and Egypt entered into an agreement to share the water. And under that agreement, Egypt decided to have about 55 BCM of water, and 18 was given to Sudan. This is almost 95% of the available water they decided to share among themselves. Then a clause was put in the agreement in case any of the upper riparian states like Ethiopia or someone makes a claim, then we both will equally share their share of water or their claims. With that kind of a small window, the agreement was concluded. You may all say that the agreement which downstream state entered without the consent of Ethiopia is not binding on Ethiopia. Well, it's not binding. But the works constructed under the color of agreement or the physical works or the infrastructure, they cannot be ignored. Under 1929 agreement and later under 59 agreement, Egypt constructed High Aswan Dam of the capacity of 161 BCM. If the total water available up to Aswan Dam is 84 BCM, as per the 59 agreement, at average, Egypt went and constructed a dam of 164 BCM. But it had a provision that 10 BCM will go towards evaporation losses, 41 BCM will go for the flood protection, and remaining 90 will be active storage. Any student of mathematics will ask a question. If the total water at Aswan Dam is 84 BCM, why did Egypt construct such a large dam? Well, it was constructed because 84 BCM is the average water, the average of 100 years taken as an index. There could be good year, where there could be 150 BCM of water or more. It depends upon the monsoon. Or there could be year where it could be less than 84 BCM. So to take advantage of the flood water, this Aswan Dam was planned. In modern language, it is called carry-over storages, that you catch the water in the good year and use it in the bad year. This is how stakes were built by Egypt to irrigate its vast land under Aswan Dam. Similarly, Sudan also constructed a couple of dams, Rosary and Sennar, to name few, to utilize water and generate power. So about 85% of the water at average was consumed by these two states. Even the flood water was planned to be consumed or used during the bad year by providing for flood storage in High Aswan Dam. The Ethiopia won't rest so as any nation, because 85% of the water comes from Ethiopia, and with the modern technology available, with the funds available, it decided to assert its rights. Initially, as I told you, we used to discuss in the international fora the fight between Sudan and Egypt. But nobody thought Ethiopia will come out with a grand proposal, though it was there, but it was not taken seriously. In 2011, Ethiopia decided to construct the Great Renaissance Dam to arrest the flows of Blue Nile. This dam proposed by the Ethiopia is not a small dam. Its capacity is 74 BCM. But the average water available up to the dam site is only about 59 BCM. Therefore, about 40% higher capacity dam is constructed by Ethiopia. The reasons are same. The reasons that apply to the construction of Aswan Dam. Ethiopia plans to absorb the flood water, the surplus water, that is the water in excess of the average water, and store it. It's all fine. Ethiopia, being an independent nation, has equal rights in the waters of Nile, so as any other nation. Nobody can be denied of its equitable share. Then what happens if one state plans it beyond its equitable share? Then how to resolve the dispute? Apparently, in this basin now, the way it stands, it seems that the high dam constructed by Ethiopia is in conflict with the planned utilizations of a couple of dams in Sudan and Aswan Dam in Egypt. The outstanding facts show if the average available water at Aswan Dam is 84 BCM, and if Ethiopia constructs in the higher reaches a dam with a capacity of 74 BCM, where will the water come from for both? In between, there is a Sudan. So the eyes are all on the surplus water, flood water. But all this flood water, surplus water sharing is not an easy job. It requires huge amount of planning. And besides that, a great sacrifice on the part of each state with regard to the dependability of utilization. Several mathematical models have been put into operation to suggest various permutations and combinations, how and in what manner the Renaissance Dam in Ethiopia, two dams in Sudan, namely Roseri and Sennar, and the High Aswan Dam can be operated without causing injury to each other. But these suggestions prepared by the experts, which are all on the net, you can read them, envisage that Egypt cannot have more than 30 BCM from Ethiopia at the dam, that is Great Renaissance Dam. But it seems that Egypt is not content with less than 40 BCM of water to be released by Ethiopia. There is a gap of about 10 BCM of water. Besides, there is a dispute with regard to the sharing of the water during a distress situation. If the water is shared at average or 50% dependability, that means it is available 1 in 2 years. It could be less than 50, sometime it could be more than 50. If it is less than 50, then there will be sharing of the distress. And the way in which distress is to be shared is not an easy thing. Usually it comes to the mind that parties should share it in a pro rata basis. But pro rata basis is not always equitable, though it sounds equitable prima facie. So in these circumstances, Egypt, Sudan, and Ethiopia have been battling out for the last couple of years to arrive at a solution. In the month of March, almost it appeared that it is impossible for the states to sit and negotiate. However, I read in the morning newspaper today that the president of South Africa, who is the head of the African Union, has taken an initiative and has been able to bring around all the three states to the negotiating table. If that is the case, we should all be happy that the parties have restarted negotiation. But let us all be clear. If the negotiation is not going to yield any result, what's the way out in international law? How will this mammoth problem to be addressed? What are the substantive rights of the party states if they have to legally resolve their disputes? And what is the forum? The international water law is crystallized by a couple of conventions and declarations of the private international law forums. The Helsinki Rules, Berlin Rules of 2004 do crystallize customary rules of international law and are also enunciated certain progressive rules which should bring equity between upstream states and downstream states. United Nations Convention on Non-Navigational Uses of International Water Courses was drafted by the International Law Commission in 1994. Later, it was opened to signature by the United Nations General Assembly after it was passed in 1997, and 35 nations have signed. It has come into force. But none of the three states, Ethiopia, Sudan, and Egypt, have signed this convention. Therefore, the convention does not strictly apply. This convention is a lawmaking convention, broadly stating or making a declaration, or what you can call it a codification of the international law, customary rules of international law, and progressive rules. If the convention doesn't apply, then what's the way out? The UN Convention, as I said, is a declaration of the customary rules of international law and incorporation of certain progressive rules. If 35 nations have endorsed it, and the International Court of Justice, in fact, before it was adopted by the UN General Assembly, had relied upon that in Gapsico case in 1995, one can safely say that UN Convention is a law which has acquired the status of customary rules of international law. If this rule is applied, how the states have to solve or resolve their problems before an arbitrator is appointed to resolve it. The big problem arises in Nile basin is the Nile basin is not only of three states again. Earlier, only two battled out, Egypt and Sudan. Now Ethiopia has come in, but there are 8 more states. So if you have to go for a grand equitable apportionment to declare the equitable shares of each of the party states. That's the only way out if it has to be legally resolved. If it can be resolved by an agreement between the three states on some principles of fairness, it's a different matter. But if it has to be resolved by proper application of the rules of equitable apportionment, then all other basin states will have to be involved. So all 11 states will have to stake their claim before the fact-finding body or an arbitrator, or if all of them submit by an agreement to the International Court of Justice. If that were to happen, how will it work out? The first thing and the most important difficulty Ethiopia would face is 1902 agreement between Ethiopia or Ethiopian king and the Britain acting on behalf of Egypt. Under the said agreement, Ethiopia could not have constructed the dam without first entering into an agreement with the downstream states. In other words, without taking their consent. Therefore, the inception, the initial starting of the dam comes into trouble. Equity does not favor a state which has illegally taken up the construction. But the fundamental question is, does this agreement survive? This was an agreement entered in 1902 under different conditions. After 118 years, you cannot really hold Ethiopia bound by such an agreement. Moreover, Ethiopia can argue that this agreement requiring it to take consent of the downstream state is in conflict with the norms of international law, the jus cogens, preemptory norm of international law. In the arbitration between France and Spain relating to the Lake Lano, a specific principle has been laid down that no state is under obligation to obtain the consent of another state before starting the construction of a project. If such consent becomes necessary, then the other state gets a veto power, which is inconsistent with rules of equality of states. Therefore, even if the agreement were to technically survive, it's open to the Ethiopia to argue that it is inconsistent with the peremptory norm of international law. Next hurdle is, okay, the agreement goes of 1902. Ethiopia, what it has done by constructing unilaterally the dam does not have a taint of illegality. Fine, to that extent, to start with. Then the next question comes, how do you apportion the water? How do you say that the dam constructed by Ethiopia of the huge capacity of 74 MAF is a part of its equitable share, or it is not in excess of its share? To determine an equitable share of a state, several factors are employed. Socioeconomic factors, so many things will follow. But the most important factor that will stare at the face again is the existing utilizations. Though Ethiopia was not a party to the agreement between the Sudan and Egypt to develop Nile water, and together took away nearly about 90% of the water. And they say that at the moment, Sudan uses about 18.6 BCM of water. Egypt uses about 55 BCM of water. Subject to the verification of the claims, this water becomes a water of the established economy. So existing uses cannot be ignored. It may not have the status of prescriptive rights, may or may not have. It depends upon how Egypt would argue the case. There are many authorities that if a dam is constructed and it has acquired certain status for storage and the upstream state has acquiesced into that for years together, then some kind of a prescriptive right arises. May or may not be, but that is the argument. Leave aside the strict legal principles, but one thing is clear, that in equity, the existing utilization has to be as far as possible to be accommodated. Unless Ethiopia shows that the existing utilizations claimed by Egypt and Sudan is not a reasonable utilization, but it composes of large amount of wastages which go to sea. It's possible, and it's a very good argument to argue for the Ethiopia. Besides, the question of groundwater utilization also comes in. If there is a plenty of groundwater, whoever has got it, he has to account it, and that has to be also taken into as a factor. So with these things, the dispute, which has caused concern to the regional peace in Africa, and which may pose a threat to the international peace, and at least to the international trade. As I said, about 13% of the trade is dependent on Suez Canal. The dispute has to be resolved peacefully by applying the rules of equitable apportionment. I'm sure in course of time, the three-party states will realize the need for a peace and arrive at a settlement. If they do not arrive at a settlement, they will at least enter into an agreement to have the matter referred to the independent adjudicatory authority, either an arbitrator or International Court of Justice. Last month, in fact, Egypt registered its complaint before the United Nations Security Council. Security Council certainly has a role to play in bringing warring states on the table. In fact, the complaint could be the reason for African Union to activate itself and bring the parties on the negotiating table. As I said, the main concern in the negotiating table, before the negotiating table, is not the grand equitable apportionment, though that may be hovering on their head, but immediately is how to, if it can be solved by some kind of a principle of fairness, by joint and integrated operation of the dam. I hear from various sources on the net that Ethiopia started filling up the dam, and this year it proposes to fill up about 18 BCM of water. So to the extent of 18 BCM of water, the downstream states, namely Sudan and Egypt, will suffer. Next year, it will further continue. It will take about 5 years, according to the plan of Ethiopia, to once have the full dam up to 74 BCM. Once that is done, thereafter, the releases will start because Ethiopia is not planning to use water for any consumptive purpose. It will be only using it for generation of electricity. The water will go down for the benefit of Sudan and Egypt. But the filling period of first 5 years are very crucial. Subsequently, what is crucial is guaranteed releases of water by Ethiopia, and particularly in the bad years. These are the things which are to be sorted out, and we'll all hope that they'll sort out and spare the world from the concerns that may arise in case there is armed conflict and there is some kind of a blockade of Suez Canal. Thank you very much for listening to me patiently. I'm sure you'll enjoy the lecture, although this topic is a bit dry. Hope I was able to make it as simple as possible. Thank you very much.
So, thank you, sir.
Hello.
Yes, sir.
Yeah,
Yes, sir.
you asked the person in charge of question answer session to coordinate.
Yes, sir.
Okay.
Thank you, sir, for sharing the facts, analysis, and various valuable insights about the Grand Ethiopian Renaissance Dam. Well, now we move on to the next segment, that is the question answer part of the session. And I hope your questions have been posted to the co-host, Ms. Niharika. I now hand over the platform to Ms. Purnashri, student, University Law College, Bangalore University, to carry out the Q&A session. Over to you, Purnashri.
Thank you very much, Pooja. Now we'll be starting with the Q&A session. Sir, the first question is from Hita K, University Law College, Bangalore University. Question is, in November 2019, Egypt's president invited United States of America to mediate the dispute. Did it prove to be fruitful or productive? Over to you, sir.
Yeah. Egypt invited a third party, and that is a superpower, to mediate and solve the dispute. President Trump took keen interest. Dozens of US diplomats, engineers, and lawyers flew down to Cairo and went around, inspected the project. They had a couple of studies conducted quickly to reconcile the conflicting interest and arrive at a sort of a solution which should be acceptable to both. But unfortunately, it didn't work out. Ethiopia is very suspicious about third-party intervention, so it failed. Yeah.
Thank you, sir.
Yeah.
Thank you, sir. So we'll proceed with the next question.
Please.
It's from Vinay from University Law College. So the question is, what
Yes.
The impact of this crisis on farmers because Egypt relies on Nile for 90% of its water supply. It is apprehensive that a rapid filling of reservoir by Ethiopia would cause a drastic reduction in water supply. Over to you, sir.
Yeah. As I explained while speaking, Egypt and Sudan together have already utilized 90% of the water. 55 BCM of the water is utilized in Egypt. About 18 BCM is utilized in Sudan. The total available water at Aswan Dam is 84 BCM. If this dam were to be constructed by Ethiopia, certainly it will cut into the storage of Egypt, that is Egyptian dam, namely Aswan Dam. Aswan Dam caters to the large irrigation in the delta, historic delta, very precious from the point of Egypt. There will be immediate concern. But one thing we must remember that there are always technologies available to reduce the water utilization by improved methods. To some extent, Egypt can help itself by improving the irrigation methodology and changing the cropping pattern from water guzzling crops to the water saving crops. Nevertheless, the dam as planned by Ethiopia is going to affect Egyptian interest. Therefore, it also requires sacrifice on the part of Ethiopia if there has to be an agreed solution to reduce its planned utilization for generation of 6,000 megawatt of power. If hydrologists are able to find by mathematical modeling some kind of an integrated operation, I'm not sure about it, it's fine. But if it is not possible, which requires a lot of cooperation, then there has to be a reduction of water utilization, both by Egypt as well as Ethiopia, to adjust each other. Yeah.
Thank you, sir. The next question is from one of our faculty member, Dr. Jyoti Vishwanath ma'am. So the question is, sir, comment on the role of China in the Nile water dispute as China is funding construction of these big dams. Over to you, sir.
Yeah, thank you very much. China has been funding construction of big dams. In fact, it has been funding the construction of this Ethiopian dam also. It has high financial stakes. But that's the question between the Ethiopia and China. If China is making funds available as a creditor, it may have some interest in bringing about a solution between the warring states. So as any one of other countries also. America has also an interest. So as in India also has an interest. Because as I said, 13% of the trade passes through the Suez Canal. So all these important powers in the world have a stake in peaceful resolution of this dispute.
Thank you, sir.
Thank you.
The next question is from Rajaram Naik, research scholar from Karnataka University. So the question is whether the principle of equitable apportionment adopted between the countries, If yes, can you please highlight a little more? Over to you, sir.
Yeah. The international law, as I said, after dating with Harmon Doctrine and Riparian Doctrine, which favored lower riparian, Harmon favored the upper riparian, has finally settled down to equitable apportionment. But still, there are various principles within the equitable apportionment doctrine which favor one or the other state. In this dispute, the most important principle that is going to stare at the face is what protection to be given to the existing utilizations on which already economy is built in the Egypt and Sudan. And if full protection is given to these utilizations, will it drastically cut into the equitable share otherwise Ethiopia is entitled to? Besides, there will be other issues, accountability of groundwater, and so many things. But broadly, the issue will be how to reconcile Egyptians claim to generate 6,000 megawatt of power by having a storage of 74 BCM and Egypt's claim of 55 BCM as its annual utilization and Sudan's claim of about 18 BCM as its annual utilization. The equities will have to finally, as I already answered the previous questions, have to make adjustments based upon what is just and fair in a given situation, what is non-discriminatory, what is not arbitrary. All fine rules of equity go into while analyzing each and every claim, every development, every expansion that has taken place in the last 50, 60 years in Egypt. It's not that the entire 55 will be straightway be accepted as existing. First, the wastage component has to be addressed. Second, to what extent groundwater can replace has to be addressed. Thirdly, the Egypt will have to address the question of saving by improved method of irrigation. And it is for the Egypt to argue out its case, addressing these questions. At the same time, Ethiopia also has to address whether it has any other alternate resources to produce the power. Why should at all it utilize the water to produce? Can it not produce the power with the help of coal? Can it not produce the power elsewhere? Can it not produce in a different manner? All these questions will come up when states sit for apportionment based on the basis of equitable apportionment, or if a fact finder or arbitrator has to consider weighing equities by considering rival claims of the states.
Thank you, sir. So the last question is from a student in University Law College. The question is, are there any cases parameteria to the current water dispute? If yes, how was it reformed? Over to you, sir.
Well, there are a lot of cases are there. If you can click on the internet, international water law or international water disputes, you'll come across several cases. You'll come across several interstate disputes in the federal. Can you hear me? There are some disturbance.
Yes, sir. We can.
There are many interstate disputes in a federal system where again the rules of equitable apportionment are applied as applied in India also. So as in the United States of America. In fact, federal disputes have contributed more to the growth of international law in this regard. The uniqueness of this dam is a little different because it has already been constructed. If it had not been constructed, it would have been different. When India proposed construction of Satluj Dam, Pakran Dam under the Satluj scheme, Pakistan objected. The World Bank did not permit India to proceed with the construction until the dispute is resolved. Finally, the World Bank itself brokered and solved the dispute by 1961 Indus Treaty. But here in this case, already the dam has been constructed. And Ethiopia has started filling up the dam this year. So this has really crossed the danger level. It can no more be ignored by the world community that it is a bilateral issue or issue between the three states to be resolved having regard to the regional considerations. It's not so anymore. It has to be addressed at the higher level by the international community. The time has come. They must act. And in this regard, there are conventions, there are case laws which can address on the fine rules of international water law. Thank you.
Thank you.
Any more questions?
Sir. This is the end of the Q&A session, sir. Thank you very much for addressing them patiently. And now I would like to yield my floor to Pooja. Over to you.
Thank you, Purnashri. And thank you, sir, for providing the best answers and also your reviews and critical analysis.
Thank you.
Well,
Thank you. I hope all of you enjoyed. Thank you.
Thank you, sir.
Okay.
Well, what an
Thank you very much, sir.
Thank you.
Yeah.
I'm sure the participants must have learned a lot from this